Years ago, a young lady went to her gynecologist for a checkup. When she entered the examination room, she noticed a man standing in the corner with his arms crossed. Assuming the man to be a rookie doctor observing the proper way to conduct an examination, the woman disrobed and the examination proceeded. Afterwards, as she was paying for the visit, she commented on the presence of the young doctor. That's when the receptionist informed her the man was not a doctor. She said he was a lawyer friend of the doctor and that they had a regular Wednesday afternoon date to play golf. Needless to say, the woman sued the doctor and the lawyer for the intentional infliction of emotional distress. This is a type of lawsuit called a tort. That's T-O-R-T. You have the right to sue when a person through extreme or outrageous behavior intentionally or recklessly causes you severe emotional distress or mental trauma. The doctor tried to defend the suit by claiming his lawyer was present to advise him how to avoid a malpractice suit, and the lawyer claimed he was present as a legal advisor. Of course, those defenses didn't work. They both lost their professional licenses and suffered a large monetary judgment. I tell you this story because there are significant parallels with the conduct of Trump and Elon Musk. Like the doctor, Trump has a serious professional job to perform, which is the running of the government. To accomplish that job, he should employ qualified professionals to ensure the absence of recklessness. Instead, he enlists his golf buddy, who wears a baseball cap and carries his 4-year-old son into the Oval Office, where he gleefully speaks of his plans to reduce the workforce, and he sends threatening emails and dances on stage with a chainsaw to demonstrate his reckless destruction of people's livelihood. Trump's approval of this conduct has been recorded on videos. Every federal employee who has been fired or who has received one of Musk's emails has a cause of action, a right to sue Elon Musk for the tortious interference with employment, defined as when someone other than an employer interferes with another's employment relationship. Those employees and their spouses each have a right to sue Elon Musk for the intentional infliction of emotional distress, which is defined as when a person through extreme or outrageous behavior intentionally or recklessly causes severe emotional distress or mental trauma to another person. And just like in the case of the doctor in the exam room who failed to act professionally, Trump is liable too. Unlike the previous information I had provided to encourage the seeking of enforcement of the 14th Amendment, the suits I suggest against Trump and Musk don't belong in the federal courts, but should be filed in your local county courts. These two grounds for lawsuits provide for the recovery of actual damages, the monetary value of the loss of a career, causing the loss of a home, etc. The law also provides for the recovery of punitive damages. Whenever one sues for punitive damages, the wealth of the defendant is admissible evidence so that a jury, after finding liability, can reasonably determine the amount that would actually be punishment and a deterrent for such future behavior. When the defendant is a billionaire, the punitive damages award can run into the millions, and your suits should ask for millions. You should understand the mechanics of such a lawsuit. In whatever state, not federal court, you file your suit in, the defendant has to file a written answer. Considering that there are now over 200,000 federal employees entitled to bring these suits, not to mention their spouses, the legal costs for the defendants, Trump and Musk, are astronomical. Trump will be unable to avoid having to answer these suits. The immunity rule applies to criminal, not civil liability. Trump himself has filed suit against CBS while sitting as president and is maintaining civil suits even now. What's good for the goose is good for the gander. It is a cliche that every litigator dreams of someday having an extremely wealthy defendant who has committed an act making him liable for punitive damages. You should have no difficulty in finding an attorney to pursue your claim on a contingency basis. That is, your lawyer doesn't get paid until and if you recover. When I first started practicing law, I would charge a consultation fee of $30. That amount over the years grew to $100. However, I only charged a consultation fee if my client and I agreed I had provided valuable information. I believe this is the most valuable information I have ever provided.